Throughout a broker's career, they will be asked to take control over certain deposits. These may include funds for escrow purposes, good faith deposits, and other deposits such as security deposits or association fees. Brokers have a responsibility to ensure these funds are held for the benefit of the person they are intended for. The Georgia Code is specific about how these funds are to be managed. All funds received by a broker or their managing office are to be deposited into a federally insured account, which must be designated as a trust or escrow account. These accounts must be registered with the Commission. Any broker who does not regularly maintain this type of account must open one within 24 hours of receiving funds related to a real estate transaction. The Commission must be notified of where any funds for a real estate transaction are being held. Information, including account number or name, must be made available to the Commission upon the account being established. The Commission reserves the right to have access to the records for the account at two specific periods of time. First, if there is a concern about any activity in the account, and second, when the Commission is reviewing licensing requirements. In most cases, all bank accounts must be held in a bank in Georgia. There are exceptions to this, which apply to those brokers or agents who are licensed in other states. However, the Commission still retains the right to review those accounts. It is also worth noting that, provided the Commission is notified, a broker may maintain more than one trust account. Earnest money, security deposit, or other trust funds may not be used to pay a broker's commission until such time as the designated transaction has been completed. Funds shall only be disbursed from the trust account when properly authorized. There are specific rules which pertain to funds which are escrowed for the purposes of escrowing funds for reserves for taxes and insurance, or any other encumbrance. Disbursement of funds must be made only as previously agreed upon, and all involved parties must be duly notified of the date and amount of the disbursement. If the Commission suspects after examination of the paperwork associated with a trust account that there is potentially a problem, or if a licensee refuses access to the documents associated with any trust account, a report will be filed with the Georgia Attorney General. In these cases, the Attorney General may request a judge issue an order to impound the account and appoint a receiver to oversee such account. The licensee may be required to turn over to the receiver books, papers, documents, and records pertaining to the account. Should a judge issue such an order, the receiver may be given control over many aspects of a business, including the right to custody, collection, administration, winding up, and liquidation of such property and business. The Commission has the authority and obligation to maintain a real estate recovery fund. This fund shall have a balance of at least $1 million and is a research, education, and recovery fund. The purpose of the fund is to provide funds for any person harmed in a real estate transaction who is not a licensee. Any party harmed shall be entitled to collect a maximum amount of $25,000 from the fund. The monies deposited in this fund shall be collected from licensees. These funds are assessed at the time of obtaining a license and are set by the Commission. Funds are only disbursed after a court has ordered a judgment and a determination has been made as to the validity of their claim. The Commission must receive a written request for disbursal of funds within 30 days of the claim being validated by the court. The Commission does have the right to further verify the claim. When a licensee is found to have acted improperly, resulting in a claim being filed and paid by the Commission, they shall have no access to a new license until such time as the licensee has repaid the amount in full plus interest at the judgment rate. If at any time the fund does not have sufficient resources to pay any legitimate claim, the Commission shall be obligated to make such payment as funds are available for the full amount of the claim plus 4% interest on any amounts which remain unpaid. Before any payments are made on claims, judgments which may have been authorized to the aggrieved party must be turned over for the benefit of the fund. The Commission is further authorized to use this fund for education purposes, including developing courses, conducting seminars, conducting research projects impacting licensees. All licensees in Georgia agree they may be assessed an additional fee of up to $30 per person per year to maintain this fund. Any licensed broker who also acts as a community association management service provider will be required to maintain a fidelity bond, or fidelity insurance, which protects the association from any potential issues which may arise out of their handling of trust funds.